talking about civil rights today. We're going to talk a bit about issues around legislation, the role of the Supreme Court in expanding rights, and things with desegregation. So, more than not, people get confused about the difference between civil liberties and civil rights. There is some overlap, which is why people get confused. So the easiest way to remember the difference is that civil liberties are freedoms from the government, whereas civil rights are freedoms by the government. So essentially, civil rights is the government protecting us and giving us the ability to participate in the political process. So civil liberties, again, are freedoms from government intrusion, whereas civil rights are freedoms by the government. So for example, if a police officer pulls someone over and searches their car without a warrant, that's a civil liberties violation. If they pull someone over because they're black and only because of skin color, that's a civil rights issue. So civil rights protect us from discrimination based on things like gender, skin color, religion, and so on. So throughout history, there's always been this debate between the ideas put forth in the Constitution and legalized racial discrimination. On the one hand, you say all men are created equal. On the other hand, slavery is legal. So how do you decide, right? How do you have this fundamental law in a system that says everyone's created equal, but it's okay to hold people in slavery? It's okay not to let women have the right to vote, and so on. So there's often been a struggle between the idea of equal rights and the reality of the situation. And of course, we're seeing that play out today, right? The Black Lives Matter protests. We're seeing this becoming a very big discussion again. Now, legally, the 14th Amendment gives us equal protection under the law. So everyone who is a citizen of the United States is supposed to be given equal protection of the laws. But of course, this hasn't always been the case, and the lack of civil rights became pretty clear in the Dred Scott case. Dred Scott was held in slavery in Illinois, where it was legal. His owner took him to Wisconsin, where it wasn't legal, so he sued for his freedom, and the Supreme Court said, "You're not a citizen." Not even really a person, and they told him he didn't have any rights. Yeah, slaves were not really considered people, they were considered property. So they said to him, "You have no right to sue for your freedom. You're not a citizen. You're not protected." And so, of course, in retrospect, this is considered one of the worst Supreme Court decisions in history. They've had some doozies, but this one ranks pretty high up there. And it did spark off the discussion about slavery and liberation prior to the Civil War. Okay, so after the Civil War, we saw expanded rights for African Americans in particular. The 13th Amendment made slavery illegal. The 14th Amendment provided for equal protection under the law. And the 15th Amendment gave black men the right to vote, not women, but men. And in the post-Civil War Reconstruction era, when the United States was being rebuilt, we did see African American men being elected to Congress in this post-war period. 13 black men were elected to the House of Representatives, and 2 became senators. So we went from you're a slave to now you can run for political office. So obviously quite a bit of a change. But this was a very brief window of time in which they could participate. Because not long after the election of 1876 happened, and it was unclear who had won. Tilden, who was the Democratic candidate, or Hayes, the Republican. So the Democrats in the South said to the Republicans, let's make a deal. We'll let Hayes be president if you promise to drop your support for civil rights in the South. So we'll give you the presidency if you stop trying to make us treat blacks as equals. And so a compromise was reached. Republicans got the presidency, the South got to pass Jim Crow laws. So, unfortunately, this was a very short-lived period of participation for black men. Then we started to see the passage of the Jim Crow laws legalizing segregation. So unfortunately, this just wasn't a very long window of time for them to participate. Okay, so Congress did attempt to pass civil rights legislation in 1875, but the Supreme Court said, you can't do this. It's unconstitutional because you're trying to regulate what private businesses can do. So the Supreme Court in 1875 basically said, look, the 14th Amendment only protects you from discrimination by public officials. So they said you can't strike down segregation laws in private businesses, hotels, transportation, and so on. So the first attempt by the federal government to pass civil rights legislation was struck down by the Supreme Court. And then the Supreme Court decided to add insult to injury in the Plessy v. Ferguson case. This was a case involving a man in New Orleans who got onto a streetcar and was told, you have to get on a separate car because you're black. So he sued, and the Supreme Court infamously said, separate but equal is constitutional. So they upheld segregation under the pretense that as long as the facilities were equal, i.e. schools, hospitals, etc., then segregation was allowed. Again, a decision that's clearly seen as a bad one. But the argument by the court at the time was, as long as they're equal, you can have segregation. We also saw at the end of the 1800s the push for the right for women to vote. It's largely been left up to the states, so only a handful of states let women vote. Wyoming, Colorado, Utah, Idaho, and Montana. Ironically enough, we had the first woman elected to the House of Representatives in 1916. Jeanette Rankin was elected to Congress from Montana. So we had a woman in Congress prior to women getting the right to vote on the national level. And kind of seeing the absurdity of that. So eventually, after World War I, the women's suffrage movement was finally able to convince President Wilson to get on board with the movement, and the 19th Amendment was ratified in 1920. So 100 years ago, women got the right to vote. Yeah, well, and they had to fight pretty hard for it. Like, women would go on hunger strikes and be force fed in prisons. They were tossed in jails, beaten sometimes. They really had to fight for the right to vote. There's all these cartoons saying if you allow women to vote, they'll, take over the household, they'll subjugate men, they'll stop getting married and having children, like all these crazy, crazy things that were being said. And Jeanette Rankin was also really kind of the first progressive in many ways. She opposed the entry of the U.S. into World War I, pushed for more women's rights, labor rights. She was a trailblazer in a lot of ways. Also, fun fact, women weren't allowed to wear pants on the floor of Congress until 1993. Yeah. Okay. Post-World War II, President Truman said, "We've got these troops coming home from abroad, fighting for freedom from discrimination and coming back to segregation. So maybe we should take a look at that." So he created the President's Commission on Civil Rights to investigate civil rights problems across the U.S. And what the commission found was, yes, there's a pattern of discrimination. Yes, there are problems with civil rights. But the commission wasn't sure that the federal government had the right to pass national civil rights legislation. They thought it was a state issue, so they could point out inequality. They weren't sure what they could do about it. Truman did take the step of issuing an executive order to desegregate the troops. But that's about as far as he got in terms of civil rights during his time in office. The Supreme Court did help deal with cases of racial discrimination before, during, and after World War II. In 1938, there was a challenge to a Missouri law that said black students who wanted to attend law school would be sent out of state and the state would pay their tuition rather than let them attend the University of Missouri Law School. So of course they got sued for this, and the Supreme Court said, you gotta let them into the law school. You can't deny them admissions. And then in 1944, or sorry, I'm getting ahead of myself. In 1944, they did strike down white-only primaries in a lot of states. Minorities tended to vote Republican during this time period. Whites tended to vote Democrat, so Democrats didn't want minorities voting in the South, but the Supreme Court did eventually strike down white-only primaries. They also had to tackle issues with discrimination in housing sales. The sale of a house, sometimes the seller used to put a provision in the sale contract that the future owner of the house couldn't sell to someone who was black, or Hispanic, or Jewish. And the Supreme Court came back and said, you can't do that. You can't tell the future owners of the house whom they're allowed to sell to. So they struck that down and said you can't put a provision in saying this house can't be sold to a minority. And then finally, in 1954, the Supreme Court reversed its decision in Plessy And Brown versus the Board of Education was actually 4 separate cases combined by the NAACP to push the matter of school segregation forward. And the Supreme Court finally said, separate but equal does not exist. Clearly, there are issues of inequality in education. So they finally reversed Plessy and said, schools have to be desegregated, that school segregation was a violation of the 14th Amendment. And one of the lawyers involved in the Brown case was Thurgood Marshall, who later went on to become a Supreme Court justice and the first African-American Supreme Court justice in the 1960s. Okay, any questions? Any questions online? Okay. So essentially what ended up happening was with Brown versus the Board of Education, the test then became, is the law in question constitutional? If it's not constitutional, then of course it needs to be dealt with. Segregation was not constitutional. Therefore, it had to be overturned. But there was a particularly interesting problem when it came to dealing with issues of desegregation. In the South, it tended to be what's called de jure discrimination, legally enshrined. So in the South, clearly it was law that segregation was allowed. You saw signs and posters and people like the governor of Alabama, George Wallace, in his inauguration speech saying segregation now, segregation forever. On the other hand, in the North, you had what's called de facto discrimination. There weren't Jim Crow laws, but there's definitely a pattern of discrimination, of segregation. But it was more cultural. So for example, in Chicago, if you were African American, you could live on the south side, but don't you dare set foot on the north side. Or in Boston, if you were African American, no way would you try to live in the North End because that was dominated by Italian Americans. There were no laws saying that you couldn't live there, but the culture made it very clear that you were not welcome. That if you tried to move into this neighborhood, you would get a lot of pushback from the neighbors, and the landlords probably wouldn't even rent to you. It's easier to tackle segregation that's legal, right? It's a lot harder to tackle de facto discrimination. So there were two on their hands. One, overturning legalized segregation, and two, dealing with the culture of segregation throughout the North. And they had quite the challenge on their hands. In the South, it took the form of the governors blockading the doors to the schools and saying, we're not going to let black students register. The governor of Alabama stood on the steps of the University of Alabama and had to get talked and taken down by the National Guard. In Little Rock, Arkansas, President Eisenhower placed the entire city under martial law and had the National Guard escorting young black children into the schools to register. So the federal government had to flex its muscle, had to say to the states, you will comply with this decision or else. We will take food if we have to, and we will make you desegregate. And the Supreme Court jumped in and in the Cooper case said, you're bound by our decisions, even if you don't like them. Federal law supersedes state law. You cannot refuse to implement a Supreme Court decision. So the Cooper case was interesting for two reasons. One, it was a unanimous decision, which never happens in the Supreme Court. And two, all of the justices signed on the decision. So the Supreme Court was also flexing its muscle and saying, look, you don't have to like what we say, but you're damn well going to do it. So get in line or we'll make you cooperate. Okay, so it was one thing to desegregate the schools. It was an entirely different matter to tackle issues of hotels, restaurants, etc. So we saw largely nonviolent protests being used. The Montgomery bus fight is, of course, famous because people think about Rosa Parks refusing to give up her seat and being arrested. But she actually wasn't the first woman to refuse to give up her seat. There was another woman named Claudette Colvin who was arrested for refusing to give up her seat. But the NAACP didn't think she would make a good face for the movement. She was young, she was a little bit more brash, she was possibly pregnant at the time, so they said, she's not a good face for the movement. So they waited until someone more respectable, Rosa Parks, middle-aged, middle class, got arrested, and then they used her as the face of the movement. And so the Montgomery bus boycott lasted a little over a year until the city finally agreed to desegregate the buses. Correct, yeah. Refused to ride the buses. They would walk, they would get walking, carpooling, yeah. Yep. It was very peaceful, yeah. Yep. And that was largely, I mean, yes, violence did happen, of course, but the movements were largely nonviolent. The Southern Christian Leadership Conference under Dr. King and the Student Nonviolent Coordinating Committee, led by people like John Lewis, knew that if they used nonviolence, they would get people on their side. If you're peacefully demonstrating and the police use a water cannon on you, or let dogs bite you, or beat you with their clubs, obviously people are going to be more sympathetic to the protesters. They're going to take their side more often than not. And so they used sit-ins and boycotts and marches. And if they were told to, put their hands up, they did. They didn't resist arrest. They didn't fight back. People would dump food on them. They would move. They were committed to nonviolence. So they were met with pretty extreme responses. And a good example of this is what became known as the Bloody Sunday March in 1965. It was actually a series of 3 marches that were going to go from Selma to Montgomery. The first protest, Dr. King wasn't there, and when the protesters tried to walk across the Edmund Pettus Bridge, they were met with extreme violence. And I'm going to show you what that looked like really quick. Oh yeah, the police were waiting. The police, people who opposed civil rights. So that's John Lewis on the ground. He had his skull fractured in the protest, ended up with permanent scars from it. So they would be beaten, as you can see here, right? They're beating up on unarmed protesters. And yeah, it was largely the cops who would show up and beat the protesters, carrying Confederate flags and just beating on them. So yeah, John Lewis had his skull fractured at that first march. Police tear gas, they'd use water cannons, police dogs, etc. People were pretty badly beaten. So the second protest, or the second attempted march, Dr. King was there, but they decided not to go forward with the march because they were afraid of more violence, more police brutality. So they called off the march, but what ended up happening was a Unitarian Universalist in Boston was beaten up by white supremacists and later died from his injuries. The third protest, the third march, was allowed to go forward because President Johnson said to Governor Wallace, "You will let them through," and so they were allowed to do the march. But they faced a lot of violence. And so they did get a lot of support from white in the North who were horrified by what they were seeing. Now, President Kennedy wasn't that strong on civil rights. He's kind of lukewarm. So when President Johnson took over after Kennedy was assassinated, he started pushing more for civil rights. And he was able to get Congress to pass the Civil Rights Act of 1964, which outlawed discrimination in schools, hotels, restaurants, gas stations, and so on. No more white drinking fountain or black drinking fountain. No more, you can't use the swimming pool at a hotel if you're black. All of that became illegal. The federal government ended up filing something like 400 lawsuits to force the states to comply. It wasn't instantaneous. It took the better part of a decade to fully get segregation laws overturned. And of course, we do still see issues with discrimination based on race. Studies have found in large cities like New York City, taxi cab drivers don't want to pick up African American passengers in bad neighborhoods or early in the morning. And of course, issues with police violence, the Black Lives Matter movement, it's a work in progress. The Civil Rights Act of 1964 is only 56 years old. We're not talking ancient history here. We're talking your grandparents would probably remember a lot of this. So it's a work in progress. There's still a lot of work that we need to do on this particular issue. Okay, so to deal with school desegregation, to support the Brown decision, Title IV of the Civil Rights Act gives the executive branch the right to implement a court order for desegregation. So instead of having to wait for parents to complain, for individual complaints, the federal government could supervise the schools and say, are you complying with Brown? Are you complying with the Civil Rights Act? Are you doing what we're telling you to do? So parents no longer had to file complaints. The federal government came in and said, we're going to fix this. Title VI of the Act also gives the federal government the right to withhold grants and aid if a school system isn't complying with desegregation. So if a school district said, we'll desegregate over our cold, dead bodies, the U.S. government could say, fine, no funding for the next year. One way or the other, they were going to get people to comply. Now, desegregation wasn't just a problem in the South. It was also a problem in the North. I used to live in Boston. It's a great city, but it does have a history of problems with racism. And in the 1970s, there's a huge problem around the system of busing. To enforce desegregation, they started transferring students to different schools and setting up the bus system, right, that we're very familiar with today, busing students to new school districts. Well, there are complaints from parents. I don't want my kid in that school district. That's a lousy school district. Don't you dare move my kid. And so there's such an uproar in Boston that President Nixon cut off all of the funding to the city until they agreed to comply with this. So it wasn't just in the South that they had to force desegregation. It was also in the North, and the federal government really had to use its powers to get the states to knock it off. But eventually, over time, we did start to see more compliance with the law. And in 1991, the Supreme Court said, look, if a school district can prove it's made a good faith effort to desegregate, we will allow them to ask for federal supervision to be removed. So if school districts in the South were complying and they could prove it, then the federal government would stop overseeing these particular school districts. So there are still occasional examples of schools practicing segregation. There's a school district in Dallas, I believe it was, like 5 or 6 years ago, that was practicing segregation. What they would do is they would put the white kids into one classroom in the school and the minority kids into a different one. And they tried to argue that was segregation, and the court said, that is segregation, you can't do that. The fact that they even thought they could get away with it is insane, but yeah, they tried it. And keep in mind, it took longer to desegregate privates as well because they're not subject to the same rules as public schools. So they had to fight to get that taken care of as well. So that took even longer to deal with segregation in private schools. In private schools, for example, Catholic schools can refuse to hire someone for being gay because they're private, so they don't fall under the same laws as the rest of the schools would. There's also been issues, of course, with employment discrimination. Now, Title VII of the Civil Rights Act says you cannot discriminate on the basis of color, religion, race, sex, and national origin. Recently, the Supreme Court said Title VII extends to sexual orientation as well. That's a brand new classification. So a company cannot refuse to hire someone for being black or Muslim or from another country originally, and they can't fire someone because they are Muslim or Jewish or Vietnamese. To help enforce Title VII, the Equal Employment Opportunity Commission, or the EEOC, was created to investigate claims of discrimination. Because Title VII outlaws discrimination by all private and public employers. So the EEOC can file a claim on behalf of someone rather than wait for a grievance to be filed. So for example, in the Abercrombie and Fitch case, when the Muslim woman was told she couldn't wear her hijab because it violated the dress code, the EEOC sued Abercrombie and Fitch on her behalf. So you can file a complaint and the EEOC can investigate and take action. By law, your employer is required to provide a copy of information about how to file a claim with the EEOC somewhere employees can see it, like a break room where you clock in. By law, that information has to be posted. If you don't see it in your workplace, ask someone and remind them it's illegal not to have that information posted. The problem with the EEOC was that originally the burden of proof was on the person filing the complaint. So you had to prove that you were being discriminated against. Obviously, that's pretty tricky. Most employers aren't going to come right out and say, oh yeah, we refuse to hire you because you're Jewish. They're usually smarter than that. Although there was a case, and I think it was Jimmy John's, a manager was stupid enough to send a text message to a woman and say, yeah, we're going to rescind your hiring because you're pregnant. And yeah, big mistake. Big mistake. They're not usually that stupid. They can be, but they're not usually that stupid, right? So it's a lot harder to prove it if they're not coming right out and saying it. So in the 1970s, the Supreme Court was asked to take a look at a case where black employees at a North Carolina power plant were being kept in one department and denied promotions routinely. So in that case, they finally said, you know what? The burden of proof shouldn't be on the person complaining, but on the company. So you don't have to prove you were discriminated against. They have to prove that you weren't discriminated against. So if you file a complaint, you no longer have to prove it was discrimination. Your employer has to prove it wasn't. So this is why employers have to be able to justify certain requirements for a job. So for example, Amazon can say to work in our warehouse, you have to be able to lift 50 pounds. That's reasonable because you're going to be lifting heavy objects. What they can't do is turn around and say, we won't hire women to work in the warehouse because if women meet the requirements, you can't discriminate against them on that basis. You can ask a professor to have a master's degree to teach, but you can't say you can't apply for this job or get it because you're white, etc. So there can be requirements for a job that are considered necessary, but if you meet those qualifications, they can't refuse to at least look at your application. And the good thing with the EEOC is if they decide to take up your claim and investigate it, you're not on the hook for the lawyers or the court costs or anything like that. So it helps people who maybe wouldn't be able to afford a lawyer to get the ball rolling on a case as well. And also, if you think your civil liberties or civil rights have been violated, you can contact the ACLU, the NAACP, LULAC. There's a couple of organizations that would maybe take a look at your case and say, you know what, you've got grounds for a case here, let's help you out with this. All right, in terms of voting rights, throughout most of the South, there used to be what they called a poll tax. They would charge someone to register to vote or to actually vote. Now, usually it would maybe be $1 or $1.50. By today's standards, that's nothing. In the 1950s and 1960s, though, when the minimum wage was maybe $1 an hour, that's a pretty significant amount of money. So eventually, the 24th Amendment outlawed a poll tax. You cannot charge someone to register to vote, and you can't charge them at the polls. Voter registration and voting have to be free. Someone tries to charge you for it, report them. It's illegal. We've also seen issues with literacy tests. Throughout the South, they would make minorities complete a test that was often written to be exceedingly hard, harder in some cases than the test to become a U.S. citizen. And they would allow whites out of the test by using what they call the grandfather clause. If your grandfather had been eligible to vote, you could. So eventually those were outlawed as well. And eventually we saw the creation of a multilingual ballot. Here in the Valley, you can get your ballot in Spanish if you prefer. In other places, you can get it in Mandarin or Creole or Vietnamese. We've also seen the use of bilingual or multilingual poll workers. Here in the Valley, they do want poll workers who are comfortable in Spanish as well, because if you're more comfortable in Spanish and you need help with the ballot, it helps if there's someone there to help you out with that. Now, we do see issues in terms of voting with what's called gerrymandering. We're going to talk more about that when we talk about elections, but essentially, the way election districts are created in most states is by the state legislature. So the majority party in the state legislature tries to create districts that give them an advantage in elections. So for example, in Texas, we got 4 new congressional seats after 2010 election. And the Republicans originally drew up the districts so they would pretty much automatically win 3 out of the 4 districts every election. They got sued by the DOJ and had to fix it. So obviously this can cause problems with being able to vote. In a state like Illinois, for example, the Illinois 19th district, basically cuts across a couple of counties through part of a golf course in the state town on down. It's ridiculous. We're actually part of a congressional district that goes all the way to Laredo. There's absolutely no reason it should be that way, but that's the way they've done it. There's also issues with photo ID laws. Now, the Supreme Court has upheld the right for states to require you to have a photo ID to deal with the issue of voter fraud. Keep in mind that voter fraud makes up less than 1% of all ballots cast. It's actually not as big of a problem. It gets talked about a lot by both parties, but it's not the problem we make it out to be. It's pretty rare. And most instances of voter fraud are someone making a legitimate mistake, not someone trying to tamper with an election. But nonetheless, states can require you to have a photo ID. So here in Texas, you need to have a driver's license or a state identity card. Now they have struck down laws that go a little bit too far in terms of the burden. Arizona tried to pass a law requiring proof of citizenship to get registered to vote, and the court said most people don't carry those kind of documents with them. Most people don't carry their birth certificate or social security card. That's too much of a burden to place on voters. Because most of the time you have to put your social security number anyway and your driver's license number. It's not that hard to establish that someone is in fact a citizen. So they struck that down as an undue burden on the voters. And states are also allowed to set their own deadlines for registering to vote. Here in Texas, you have to be registered to vote, I believe it's at least 28 days before the election. So the election is on November 3rd, so you're coming up on the deadline to register. So if you're not registered to vote yet, you're going to want to do that as quickly as possible. Okay. The Civil Rights Act also applies to housing discrimination. The Fair Housing Act bans discrimination in the sale or rental of housing. So a landlord can't refuse to rent to someone who's black, or Muslim, or a woman. But the problem with the Fair Housing Act was that it required individuals to file a lawsuit claiming discrimination and then prove that they were discriminated against. Again, not very easy to also expensive. So eventually the Fair Housing Amendments Act was passed, and it allows the Department of Housing and Urban Development to take action if they believe there's a pattern of discrimination. So if a landlord in New York City is constantly refusing to rent to African Americans, Housing and Urban Development can come in and say, we want to see your records. Okay, you have a pattern of discrimination. We're going to fine you until you agree to comply. There's also the illegal practice of what they call redlining. Essentially, what the banks would do is refuse to give mortgages to homeowners in an entire neighborhood. So either you had to pay for your house out or you couldn't buy a house. They would also refuse to give them a mortgage to move into a nicer neighborhood. So minorities were essentially packed into certain neighborhoods that were considered affordable because you had to buy your house outright. You couldn't necessarily get a mortgage, which is illegal. So states can't say, okay, this entire section of Wesco, no mortgages, no loans for people living there. But the banks and the mortgage companies haven't always been so great about observing the rules. And in the 2008 housing crisis, it came out that the banks and mortgage companies were charging black homeowners a higher interest rate on their subprime mortgages compared to white homeowners. So minorities were losing their houses at faster rates compared to white homeowners. So eventually the banks had to pay millions in settlements for this illegal practice. You can't charge a higher interest rate based on race. It has to be because of the value of the house and the loan. It can't be because you're black or Hispanic, etc. But most of what the banks and mortgage companies were doing in 2008 was illegal anyway, so. Okay. So the Equal Protection Clause in the 14th Amendment has three separate layers of proof you have to meet. So the first level applies to a state and federal regulatory scheme. Essentially, if you're going to pass a minimum age, it has to be across the board, right? You have to be 16 to get a driver's license, 21 to buy alcohol, 18 in some states they're playing around with 21 for tobacco, but it's considered fair because it applies to everyone regardless of race, gender, etc. So that's allowed. You can have minimum ages for driver's licenses, alcohol, and for sales. The second level is where the government has to prove that some type of special classification serves an important interest. So in the Windsor case, when Edith Windsor sued because she was not given the same tax breaks as the survivor of a same-sex spouse that she would have gotten if she'd been married to an opposite sex. The argument by the government at the time was, well, we can't give same-sex couples equal treatment because then it's a problem in terms of protecting heterosexual marriage. That granting same-sex couples the same rights would essentially be harmful to heterosexual marriage. And the court tossed that out and said, absolutely not. There's no justification for this argument. There's no evidence that allowing homosexual couples the same rights will cause any problems for heterosexual couples. So they tossed that argument out and said, no. The third level is where the government has to prove that some type of discrimination serves a compelling interest. And so this is where we find the arguments around affirmative action. The government makes the argument that affirmative action is necessary to rectify past discrimination, to level the playing field for minorities who are shut out of certain jobs, college majors, and so on. By and large, the Supreme Court has upheld affirmative action as serving a compelling interest, has said that affirmative action can be used in school admissions and job applications. So affirmative action, for now, is considered necessary to level the playing field and rectify the past discrimination. So it is considered allowed. The federal government is allowed to use affirmative action. Right. Any questions or comments? No. Okay. Any questions online? Right. We're going to talk more about affirmative action next Tuesday. We're also going to talk about civil rights for various groups like Asian Americans, women, Native Americans, and so on. So remember, your paper proposal is due a week from today in Blackboard. The Dropbox is open. If for some reason you can't submit a paper proposal, let me know. It's not for credit, so don't panic when you see a 0. The system makes me assign a point value, so I was like, fine, 0, whatever. So I'll give you feedback. I'll let you know, yeah, your topic's great, or maybe, refine it a little bit. And then after next week, if you decide you want to change your paper copy, that's fine, you just have to let me know. Okay, any questions on that? No, everyone's good? Okay. So it's due by midnight, essentially, next Thursday night. If it's late, it's fine. Sometimes I know technology doesn't always work, or your computer decides it has to update right now. Yeah. So if it's a little late, don't worry about it. But try to get it in by midnight if you can.